I think we're ready to go. So welcome again, everyone, and thank you for joining us for today's webinar on the free speech implications of the ICJ proceedings in South Africa versus Israel. My name is Chantal Joris. I'm a legal officer with Article 19, and I will be moderating today's webinar. Let me just start maybe with a few housekeeping topics. The webinar is being recorded, and it will be published also after the event. We will have a moderated discussion for about 60 minutes, and then we will move to about 30 minutes of Q&A. And for that purpose, please use the Q&A chat box and your screen to submit questions to the speakers. The questions or comments will only be visible to the panelists and myself, so don't worry if you don't see them once you've submitted them, but be sure that we have received them and we will do our best to get through as many questions as time allows. Let me start perhaps with just a few words on why Article 19, a freedom of expression organization, is hosting a webinar on ICJ proceedings brought under the Genocide Convention. The information dimension of this conflict in Gaza has been significant, and Article 19 has repeatedly condemned Israel's violations of freedom of expression. This includes internet shutdowns, censorship within Israel, restrictions of access for international journalists to Gaza, and of course also the killing of an unprecedented number of journalists. And all these violations, we believe, directly also impact compliance with other core international humanitarian and international human rights principles, and they lead to increased harm for civilians on the ground as well. Several of these violations have, in fact, been highlighted in South Africa's application to the ICJ, and Article 19 has urged the ICJ to consider these and their contribution also to potential acts of genocide as it assesses the case on the merits. In addition, we believe that two of the provisional measures issued by the ICJ a few weeks ago also have a free speech dimension. In particular, Israel has been ordered to take all measures within its power to prevent and punish the direct and public incitement to genocide. And it has also been ordered to take effective measures to prevent the destruction and ensure the preservation of evidence. So to see whether we can find agreement on these and other issues in this case, I'm very pleased to introduce an excellent panel of speakers that we have with us today. First, I'd like to introduce Jiries Saadeh. He's an English qualified lawyer and solicitor advocate and a leading public international law practitioner. We also have with us Yuval Shany. He's Hersch Lauterpacht Chair in International Law, the former Dean of the Law Faculty of the Hebrew University of Jerusalem, and the former UN Human Rights Committee member. We are then joined by David Kaye, Professor of Law at the University of California, Irvine, and also former UN Special Rapporteur on Freedom of Expression. And last but not least, we have with us El-Sadany, a human rights lawyer and the executive director of TIMEP, the Tahrir Institute for Middle East Policy. Thank you so much to the four of you for joining us today. And I want to start first with unpacking the provisional order the provisional measures order by the ICJ. And Jiries, let me start with you. Can you tell us what's your take on the ICJ's order against Israel in terms of the need to prevent and punish the direct and public incitement to genocide? And do you think this case can be relevant to clarify the scope and interpretation of this application?
Well, thank you, Chantal, for the introduction and for having me on this panel. Before I get to your first question, it might be worth for the audience recalling what the Genocide Convention says about incitement, and the key provision is Article 3 of the Convention. That says the following acts shall be punishable: A, genocide; B, conspiracy to commit genocide; C, which is the relevant one here, direct and public incitement to commit genocide; D, attempt to commit genocide, and E, complicity in genocide. So that provision in Article 3 is the explicit prohibition on incitement, which, to go back to Chantal's introduction, is the legal exception to the right of free expression that Article 19 obviously advocates, and an important exception. Now, that provision is referred to in that prohibition is referred to in various other articles of the Genocide Convention, such as Article 4, which states that persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, and that doesn't matter if they're public officials. Okay, so South Africa presented significant evidence from senior figures in the Israeli government of what it asserted was direct and public incitement to commit genocide. There were various quotes, various videos that were shown in front of the court. It also presented evidence of Israeli soldiers mimicking some of that same language during the Israeli onslaught on Gaza. So in terms of my take on the ICJ's order, on this aspect of South Africa's claim, I think the first point to make is that the ICJ was clearly deeply perturbed. And in my view, I think it should have been deeply perturbed by the language of Israeli leaders and soldiers. It's notable, for example, that the court explicitly cited various statements in what is otherwise a relatively brief amount of reasoning in the order. It cited, for example, the statements of Yoav Gallant, who's the defense minister of Israel, who announced that he had ordered a complete siege of Gaza City and that there would be no electricity, no food, no fuel, and that everything was closed. It also cited the president of Israel, who now somewhat infamously said it's an entire nation out there that is responsible. It is not true, this rhetoric about civilians not aware, not involved. It is absolutely not true. So these findings were central to the reasoning of the court. And so while the court did not then make the link explicit, I think it's safe to conclude that these statements directly led to the court's subsequent order that Israel, quote, shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group in the Gaza Strip. As an aside, I do not think that those statements are relevant only to the incitement aspect, which we're dealing with on this conference. It could also be, of course, that the court will use those statements in its provisional measures, and also will use them in the merits as evidence towards other requirements of the convention. For example, the requirement for there to be intent to destroy in whole or in part a national, ethnic, racial, or religious group as such, which is the key definition of genocide. I have a couple of other brief thoughts, if I may. The first is that it's important that this order on incitement was almost unanimous, and it even included the Israeli ad hoc Judge Barak. For those who aren't aware, states who are party to contentious proceedings before the court, if they do not have a national national judge on the bench already, are entitled to appoint a national or someone else to the bench. And that's what Israel did. And even that former Israeli Supreme Court justice found was on the almost unanimous finding on the incitement element. So I think in that respect, this element of the ICJ's order takes on an arguably more central locus in this preliminary phase than even in other recent genocide cases before the court, such as Gambia versus Myanmar. Second, there was an interesting declaration by Judge Nolte, who's the German judge on the bench. So he found he was in the majority, so he did find for the provisional measures, including incitement. Although his declaration makes it clear that he was skeptical of some of South Africa's claim, but he really was clearly troubled by the statements, the rhetoric of the Israeli leaders and soldiers, and he makes it clear that that was one of the key reasons why he was in the majority on provisional measures. So I think that's my views on the judgment, or on the order rather. You also asked whether this case can be relevant to clarify the scope and interpretation of the obligation. I think the broad answer to that is not yet, not at the moment. On the whole, the ICJ's reasoning is rather scant, and that's not unusual, I should say. It's just the way they draft these preliminary measures. I don't think there is enough meat in there to provide specific guidance on clarifying the scope and interpretation of this obligation more broadly at this stage, and certainly it's a long way short of some of the detailed reasoning on incitement in the international criminal law context that we've seen, such as from the Rwanda Tribunal. There will, I'm sure there will be more in the ICJ's final judgment, but that's a few years away. And of course, there are two other cases before the court under the Genocide Convention that precede this one in time, being Gambia against Myanmar and Ukraine versus Russia. So I think I'll leave my comments there for now.
Thank you so much, Jiries. A lot to unpack here. I want to bring Yuval in to get your views as well on the question of also incitement and how it interrelates with freedom of expression, and also the relevance of these statements, as mentioned by Jiries, on establishing intent.
Yes, thank you, Chantal, and thank you for organizing this and for inviting me. This is indeed a very important discussion. First, I would say that incitement to genocide, the prohibition against incitement to genocide, is obviously an exception to Article 19. So Article 19 of the ICCPR does establish freedom of expression, and does allow for some restrictions, one of which is a restriction provided in Article 19, paragraph 3, and that is to, in order to respect the rights of others, and arguably the prohibition against incitement to genocide falls within this category with this exception. One maybe could argue for other exceptions as well, but this would appear to be the most clear location of that exception. So we are dealing here with an exception to freedom of expression. You could also make, I think, the argument that, and maybe we could discuss this further, that incitement to genocide, public and direct incitement to genocide, is a particular case of hate speech under Article 20. I would say that the two do not fully overlap in every aspect, but there certainly could be instances in which a direct and public call for genocide would also qualify as incitement to hate and to discrimination and violence, which is prohibited under Article 20. Yet I do think it is somewhat of a different. It has some specific features which render it somewhat different from what you could say a run-of-the-mill Article 20 speech, and maybe David Kaye would elaborate on this further. But what I can say preliminary is that on the one hand, you do have here a heightened risk. Genocide does seem to involve a risk of wanton violence against large numbers of people. And therefore, one could argue that in terms of the duty to suppress such speech, that duty to suppress is a heightened duty that may go beyond the way we normally treat Article 20 cases. On the other hand, when talking, so that is suppressing, for instance, limiting such speech, outlawing such speech, taking measures. On the other hand, I would say that, and this is, I think, maybe an area where the court could provide us in the future, and I agree with Joris, at this point in time, we didn't get a lot of guidance, but in terms of the threshold, I would say that so far in the criminal context, the threshold for direct and incitement to genocide has been placed rather high by the ICTR, and therefore, in terms of actually establishing criminal responsibility, because of the particular severity of this offense, there could be actually a rigid requirement. So, for instance, in the ICTR, in a case like Nahemana, there was a requirement that the statements, when read in context, wouldn't be ambiguous. So ambiguity has been seen as a potential defense claim in genocide cases. So I think this is an area where international human rights law still needs some further development on this interplay between Article 19, the interpretive canons that are pertain to exceptions to Article 19, Article 20, the interpretive canons that apply to Article 20, which we see could change according to context. And we have seen that on the online, for instance, in the online environment, there may be greater, because of risk factors, there may be greater propensity to suppress speech than in the offline where Article 20 is implicated. And again, this specific offense, the direct and public incitement to genocide, where the canons of interpretation that we have for the time being in criminal law context are quite specific. Maybe if I have a couple of more minutes, I will say on the decision itself, I generally agree with Jiries' analysis that the treatment by the court of inciting statements is somewhat unclear. In the sense that the statements could, I would say that the statements could be used in the case for three different purposes. And it's not clear to me which of these purposes was actually invoked by the court. One, it could be the offense of direct and public incitement itself under Article 3, Paragraph C of the Genocide Convention. Then it could be an evidentiary, it could be evidence for the existence of a plan. So it could be used in order to make the broader claim that there is a genocidal plan, and these statements are pieces of evidence. And then there is a third use, and I think Judge Nolte was mostly interested in that third use, and that is that these statements, even though they may not in and of themselves constitute a criminal offense, and even if they may in and of themselves would not reveal the existence of a plan, they still create a risk. They still create a discourse, an environment which could lead, for instance, soldiers on the ground to take measures that would violate the IHL or even violate the Genocide Convention. And I think the court has not been very clear on which of the three levels it deals with. So the measures themselves go to function one, to basically outlaw the direct and public incitement. Judge Nolte was mostly concerned about level 3, the risk, because for him, the genocide, the plan of genocide was somewhat implausible. But for, I would say that the statements that were chosen, for me, they do not actually fit neatly with a category 1, because the court didn't go for the most aggressive statements. And there have been more aggressive. I mean, it's not that what's in the decision is not bad enough, but I would say that there are even worse decisions which were not cited by the court. The decisions that were cited, at least President Herzog, you could say has some ambiguous features. Again, I'm not endorsing any of these statements, to be clear, but I mean, there are some ambiguous features that would generate, I think, problems for actually prosecuting this. But I think they were chosen because these are important individuals. Two are members of the Security Cabinet. One is the head of state. So maybe the court chose them either because they generate a risk factor, or maybe they could be part of an evidentiary puzzle that would indicate. So the low-ranking members of parliament or the television commentators who have been much more aggressive play less of a role in actually establishing a plan or even maybe creating this sort of environment. So I would say we still have a lot of room for further clarification, both of the law and also of the ways in which the court understands the evidence that it had used as part of the bigger framework of the case that it is working with. So I stop here.
Thanks a lot, Yuval. David, what's your perspective on this, and perhaps also this difference mentioned on this incitement to genocide versus hate speech and propaganda, and how it functions under Article 20? Is it an exception to Article 19, or is Article 19 still relevant when states pursue, prevent and punish incitement to genocide?
Right. Chantal, thank you for that, and thank you. You know, one of the things you didn't mention in introducing me was that I'm on the board of Article 19. So, just want to mention that. So, I'm not particularly concerned, because I think one of the questions is sort of, you know, what are the implications of the provisional measures, or more generally of the case for freedom of expression. I'm not particularly concerned that the measures themselves have any, you know, negative implications for freedom of expression at the moment. I don't see that right now. But I wanted to mention maybe three things that follow what's already been said, and hopefully I'll talk a little bit about Yuval's question and your question as well. But I'll just say three things, hopefully quickly. The first is to remember that, you know, before the ICJ, this is a case of state responsibility. So it's not a case that will involve the kind of close evaluation. I mean, the court is just not really built for the kind of close evaluation that the International Criminal Court would be able to do in the context of an actual prosecution for direct incitement, direct and public incitement to genocide. And so I think, just as a matter of framing, my suspicion as we start to look towards what the court would do is that they're most likely, as a state responsibility issue, to look at whether Israel, you know, actually did sort of follow up and comply with its obligation under the Genocide Convention to criminalize, to prevent direct incitement of genocide. So, and that they could possibly do even in the absence of a finding that there was direct incitement to genocide. So that's one part. It's we're in the zone of state responsibility. The second is, I think that South Africa really has its work cut out for it if the court stays true to its past statements in terms of the standards that apply to a finding of incitement to genocide. So if you go back to the Serbia-Croatia case, for example, the court was very clear. I mean, it could change, but it was very clear that it was going to look to intent, and it's not clear exactly how this plays out, but intent to commit genocide was also a part of the evaluation of a claim around direct incitement to genocide. So one thing is they potentially will be looking at intent and how that played out. Again, probably at the level of what the Israeli, you know, Attorney General or the courts might have been looking at in the interim. The other is that in the Serbia-Bosnia case, the court said that in looking to the question of proof of direct and public incitement to genocide, it would look for what it said was precise and incontrovertible evidence. So what's been presented so far and what has been analyzed in the provisional measure stage, I'm guessing is not at that level yet. It didn't have to be, because at this level, we were at a very low level of proof. And so I think looking ahead to what the court might do if and when it gets to the merit stage, I think there will be a need for South Africa to bring much more than it already has brought. And even if you look at Judge Barak's reasoning for why he joined this particular element of the interim measures, he wasn't, it didn't seem to me that he was making a claim of a legal conclusion, but he said that he voted for it to help discourage damaging rhetoric. I mean, it seemed like his vote was much more at a level of messaging and politics, or in a way, rather than the kind of close legal analysis that I think we could expect 2, 3, 4, how many years down the road. The last thing I would say is, I mean, I'll be very interested to see how the court, or if the court, does any kind of analysis as to the relationship between the Genocide Convention's prohibition on incitement and Article 19 and Article 20. I mean, there isn't, as far as I know, there isn't jurisprudence on this connection. In the ICTR, Judge Marone, in a partially dissenting opinion in the Naimana case that Yuval mentioned, he distinguished incitement to genocide from what he called mere hate speech. This is sort of a pre-social media dissent, I would say. So I think Judge Marone might have a different view in today's environment, but at least he distinguished those. But there wasn't a real evaluation of that connection between Article 19, Article 20 on the one hand, and genocide, incitement to genocide on the other. So, I mean, I'd be very interested to see, for example, if given, there's new, let's say, soft law that's developed around Article 20 in the last decade, whether the court in doing an evaluation would actually look to the Rabat plan of action with respect to national, racial, and religious advocacy that constitutes incitement to violence or hatred or discrimination. I mean, I think it would be very interesting if the court were to look to Rabat and examine questions of not only intent, which it already, I think, has signaled in previous cases that it would look to, but whether it would also look to context, whether it would look to audience, the position of the speaker. So, for example, President Herzog's statements might have a different valence than the statements of, a mere politician or, a member of the Israeli Defense Forces. So there's a lot, I think, that we don't know yet. I mean, there's a lot of room for, if anybody listening is looking for like a law review article to write to evaluate these kinds of things. Rick Wilson wrote a book on incitement in international law that gets into this that I think would be really valuable, and I imagine the court would look to as well. But as far as looking now at where we're headed, I imagine a very high bar for evidence, a state responsibility focus, and if it gets interesting, a kind of discussion of the relevance of Rabat and Article 20 in particular to evaluating incitement to genocide.
Thanks a lot, David, and I think it would be very, very valuable for the court actually to really go deep into these issues, because I do think there's a lot of unresolved questions. Mai, let me come to you first of all, if there's anything on the particular points raised that you want to react to, but also I would like to speak a little bit about the other provisional measure on that ordered Israel to prevent the destruction of evidence. From Article 19's perspective, this is linked to questions around freedom of expression and how can you preserve evidence if there's internet shutdowns, killings of journalists, etc. So I will be keen to hear from you what you think about this point.
Thank you, Chantal, and thanks to Article 19 for having me. Just very quickly in reaction, I agree with those who've spoken before me that we certainly don't know how the court will build these statements in the merits stage and into the final argument. We know that South Africa will have its work cut out for it in light of the court's history and in light of how difficult it's been to establish intent. But I just want to recognize what David said about we have a lot to analyze. I also want to say we have a lot there. I want to quickly note that lawyers have weighed in on the significance of a legal submission that was made up of 11 pages of what are potentially genocidal statements over an extended period of time by individuals in all sorts of positions and levels. In many cases, this type of even collection requires a lot more work than just a mere search on Google and X, which is what we had here. And I think it's important just to contextualize some of the legal conversation with the reality that these statements are made with a high degree of impunity and a near certainty of the evasion of accountability. And I think for me, they really drive home the importance of the order, irrespective of how the court will deal with this issue at the merits stage. With regards to your question on evidence, As you say, the order requires Israel to prevent the destruction and ensure the preservation of evidence. I absolutely agree that this entails free speech implications, and I would argue that we've already seen Israel violate this order. And I want to highlight a few prongs from a more kind of on-the-ground perspective, if you will. First, I think we see this with the intentional targeting of journalists in this war, where foreign correspondents have been denied access or have been granted limited access, and only when they embed, local journalists have really played a critical role in taking photographs and videos, in interviewing survivors, and documenting events. Certainly, this isn't only for the purpose of evidence, but we know that journalism has a big role to play when it comes to the building of cases. And as of February 28th, the Committee to Protect Journalists had documented the killing of at least 89 Palestinian journalists. Other entities have counted the number as higher. So I think this is significant when it comes to kind of who is collecting the evidence and how they're being treated by Israeli members of the IDF. In a number of occasions, Israel has actually explicitly stated that it targeted these journalists intentionally, in some cases under the pretense that they were using drones. And in other cases, investigations by independent parties have shown that they have done so. And targeting not just journalists in order to destroy evidence they have or in order to stop them from collecting further evidence, but also targeting of their families to chill their work. And so this is, I think, one really important prong when it comes to assessing how the order is being implemented or not. Second, I think we've seen this with the targeting and killing of human rights defenders and lawyers who are equally essential individuals doing documentation work in the midst of quite impossible situations. Just by way of example, at the end of February and within a single 5-day period, we saw the killing of 2 human rights lawyers who worked with the Gaza-based Palestinian Center for Human Rights, Noor Nasser Abu Noor and Dania Yaghi. And obviously lawyers, as we know, play a critical role when it comes to evidence collection, speaking to victims, etc. And so this is a second prong we should be looking at. Third, as you mentioned in the question, we see this with the communication blockout on Gaza, which makes it operationally difficult, if not in some cases impossible, to collect, relay, and preserve evidence in a timely fashion. We certainly see the mitigation of this to some degree with eSIMs and other efforts out there to stop the blackout. But whether there's access to them or not, we know that Israel's obligations to allow fuel in and to halt the blackout do not drop, even with these the availability of eSIMs. Fourth, I think we've also seen the toying with, the falsification, perhaps the misrepresentation of certain scenes, of video footage, of evidence. We saw a lot of questions raised by folks who work in OSINT in misinformation and disinformation at the scenes documented at Al-Shifa Hospital, where reportedly a nurse turned out who was speaking on behalf of what was happening at the hospital turned out to be an actress. We saw this with the false representation of scenes allegedly found at the hospital, including the whiteboard, which the individual being in the videos represented as being something else. And we saw this most recently with the videos around aid delivery and the flower massacre, where BBC just told us yesterday that Israel had edited out parts of the original footage. And so there's this fourth prong of kind of what the evidence actually looks like, what makes it to the general public, how it's preserved, and kind of how we verify what's correct and not. And then finally, I think the obstruction and failure to allow any independent fact-finding mission into Gaza or representatives of the UN who do have a history of being able to do this in a balanced and fair manner. And I think this is a really critical point as well. And so for those reasons, when I step back, I unfortunately see consistent violations of this order. And I see that there are different things that Israel should be doing, both to meet its obligations under this order and its always standing obligations under international humanitarian and human rights law.
Thank you so much, Mai. Any quick reactions from anyone to this particular preservation of evidence and freedom of expression thing before we move to the broader implications? David, yes, go ahead.
Yeah, so I just wanted to follow up on Mai's points, which I think are really important. But I didn't want to address them from either sort of a factual perspective, but more sort of because I think what she mentioned is just important from a human rights perspective. And there's an open question here about how much the court will essentially import other obligations under international law into a case that, you know, by its filing is about the Genocide Convention. To me, that's a very, I mean, as an international law nerd, I suppose, that's a very interesting question, right? To what extent will it do that? And it also highlights, I think, something that for many people might be a bit of a confusion, which is why the Genocide Convention in the first place, right? Because the kinds of, you know, allegations and violations or potential violations that Mai mentioned make sense under other areas of international law, but there was no other basis for South Africa to bring a claim in the ICJ. So I think that's, you know, there will be different tracks, but I think the kinds of things that Mai mentioned, it will be very interesting to see if the court actually integrates those into its evaluation of sort of the evidence obligation in a Genocide Convention case.
Yes, Yuval, also let me maybe just merge it because David has now moved into what I was planning to discuss, specifically this question that it's obligations under the Genocide Convention that are before the ICJ. Interestingly, also Nicaragua has filed this case against Germany, and because of the compulsory jurisdiction declaration they've brought in directly also the Geneva Conventions. But in this case, we have the Genocide Convention because it allows most of the states to go before the ICJ. And Yuval, and then also David and others, do you think the court should address the human rights violations or humanitarian law violations as well? For example, on our interest, the freedom of expression violations that could contribute as well to potential acts of genocide.
Thank you. So okay, I have something to say about that, but maybe by way of preliminary points, I would associate myself with what David said about this is a genocide case, so therefore the court would be limited with regard to certain other alleged or perceived violations of IHL. I also wanted us to be a bit more, perhaps, in terms. I would be a bit more skeptical about reading too much also into the provisional measures themselves. So, for instance, the fact finding was something that South Africa requested in the application, and the court didn't accede to that request. I think it would be quite unlikely that the court would read that specific request indirectly by way of interpretation into the preservation of evidence requirements. So I think preservation of evidence, which the court actually doesn't really explain in the decision what it actually means, but it normally has been understood in the context of cases which, although they pertain to state responsibility, also have an international criminal law dimension, in the sense that the state is required to prevent and suppress the commission of crimes. It was typically understood more as being related to actually evidence about the crimes that are committed. So some of the points which may raise, and I think are important points, such, for instance, misrepresentation before the public of what had happened. This in of itself doesn't pertain directly to preservation of evidence. I mean, you could have all the evidence, you could preserve it, and then when you send it to the BBC or wherever you send it, you send something quite different. So I would be a bit careful into reading too much both into the provisional measures, and also accepting that there are limits to what the court can do in this case. You're right, Chantal, that the Nicaragua case would potentially open up many other issues, because it is not based only on the Genocide Convention. It also raises issues under IHL and under other norms of international law. But that case would, I think, has some serious procedural problems regarding these other allegations, precisely because they're not part of the case against Israel, which actually Nicaragua asked to join also. So we'll see whether the court would be willing to even take on these allegations, these heads of claim. On the issue the broader issue that you raised, which is indeed the question of how willing will the court be to take on the broader freedom of expression issues, especially the issues relating to the alleged violations by Israel, such as targeting reporters or internet shutdowns, etc. So I think there may be a room for such allegations to make their way into the case if you could actually establish that this is if you are able, to establish that there is a plan, and that this is part of the plan, that part of the plan, for instance, is to target journalists so word doesn't come out about what's happening, or if the plan is to shut down the internet so that life-saving information is no longer available to the domestic population or rescue teams. But of course, this is something that would need to be proven. And as David suggested, when we're talking about the genocide case, the standard of proof for the court has been quite high. According to the first case, that Bosnia-Serbia, it's fully conclusive evidence, which is a very high threshold. Part of I think one of the problems with litigating genocide cases is in fact that sometimes, because the court has established this high threshold and has been basically taking the position that it is willing to make some inferences from circumstantial evidence, but only if the only plausible inference is genocidal. So paradoxically, if you are engaged in a violation which is meant to facilitate not genocide but another crime, then this is no longer the only plausible inference. So we are in a way in a sort of a bizarro land, where actually arguing that you are committing one crime may take you off the hook for when you are being charged with the other crime. So I would say that the road exists, but it is a very long and winding and difficult road to take. I will just say, for the sake of completion, that we are talking on the basis of assumptions about violations, and I'm sure that in certain areas there would be violations that could be shown. But some of the measures, for instance, internet shutdowns, are not such a clear-cut temporary internet shutdowns are not such a clear-cut case of an IHL violation, given that communication has been understood as a dual-use target. Of course, there are questions of proportionality, etc., that need to be addressed. But I'm just flagging here some cautionary flag that we should not assume that every case where a human right had been violated in times of war entails it cannot be justified within the framework either of human rights or IHL. But this is not the focus of our discussion now. Thank you.
Chantal, if I may, very quickly, I want to react to David and Yuval's point. I agree with Yuval's one of his most recent points on how these violations of human rights could be read to be potentially, the argument I imagine South Africa will make is that these violations of human rights could be read to be part of a plan. I don't think that's easy per se, but I do think this is the direction they're going to go in. And I think certainly reasonable minds can differ, but I think these prongs exist in a significant enough manner to be able to tell a story. Whether or not the court will buy it is a different question, but I do point these prongs out not to make arguments that the court is all of a sudden going to take up decisions on human rights, if you will, but rather that an analysis of these human rights violations are critical, in my opinion, to understanding the larger story of genocide, if you will, in this case. And that's precisely why I kind of wanted to bring us back to what was happening on the ground, because I do believe that it's really the developments on the ground, the details that build up to this larger story of whether or not ultimately genocide is taking place.
And if I may add briefly to that, I think one thing that maybe we haven't thought about is the fact that 2 weeks later there was this advisory opinion before the court about the occupation in the West Bank, in Jerusalem and Gaza, and South Africa made the argument there about the apartheid system practiced by Israel being a form of genocide as well. And I think it's going to be, they're the same judges, they are two different cases, but the judges have heard arguments from South Africa that are going to influence its finding on genocide. So whether those arguments about Israel's sort of actions towards Palestinians more broadly outside of the last 5 months in Gaza feed into its ultimate determinations, I think we shouldn't rule it out. And clearly the advisory opinion is going to come out well before the final merits judgment in this case, and could have significant impact on it. I also just briefly, I do accept that Bosnia-Serbia has a very high threshold. I don't think it's impossible that the court will reconsider that. It was very heavily criticised after Bosnia-Serbia. And there are 2 cases, as I mentioned, preceding South Africa versus Israel in the Genocide Convention oeuvre going through the court now. So who knows if in Myanmar and Russia, Ukraine, there'll be a reconsideration of that very high threshold.
Thanks a lot. David, I don't know if you want to add something to these points now.
Well, I can always add something. So 2 very quick things. One is just, this is very much like a footnote to a footnote point, but the makeup of the court actually has changed a little bit, so there's actually now a permanent judge from South Africa who's been elected, Jiries Saadeh, who will be on the court and will be on the court, for the long haul. And so to the extent to which that will, implicate any of the dynamics on the case, because Professor Saadeh sort of has a kind of a long history in international law, there might be something there. But again, this is sort of a footnote. There's also a new American judge, a new judge from Mexico. So, there could be, at least on the margins, some different kinds of conversations that take place. I want to also pick up on Mai's point again, because again, I think there's a way in which, court cases dealing with genocide claims and some other claims in the area of the law of armed conflict have so kind of legalized these questions that the outcomes might be a little bit foreign to, say, Raphael Lemkin, who was sort of one of the initial inspirers of the Genocide Convention. And I say that mainly because, to the extent to which the courts look, as courts should do, at very specific questions of evidence and sort of particularized questions of whether this particular evidence supports this particular prosecution, let's say, of this particular individual, is very different from the overarching spirit of the Genocide Convention, which is kind of a sense of breadth and scope of and accretion of incitement and actions on the ground that all together paint a picture of genocide. And that is what I think many people take away as sort of the political implications of the Genocide Convention. And that's very different from what happens in the courtrooms. And so just as we're looking at this, I think what I'm trying to say is there's a way in which we need to distinguish legal responsibility in the context of the ICJ. In later, probably Karim Khan will be bringing cases related, on the Hamas side and the Israel side, related to these kinds of questions. It'll be very specific, and that shouldn't distract us from sort of the overall picture in the context of, sort of the political questions around genocide, but also IHL and human rights law more generally. It's just that all of those things are not necessarily a part of the very specific case that's in front of us.
Thanks a lot, David. I want to move to a slightly different topic, and I also see at least 2 questions in the chat that deal with that as well. where we can't forget the responsibilities of online platforms in this context. They host a lot of content that is inciting. At the same time, they host a lot of content that documents violations of humanitarian law, human rights law, international criminal law, and they have been criticized for, on the one hand, leaving too much inciting content up or suppressing too much content that is important documentation. So needless to say, they're not a party to these proceedings, but why should they pay attention, and why should they care about them? Let me start with you.
Sure. So you rightly say that the case at hand, and we've discussed how this is really about state responsibility. And so online platforms are not in question, if you will, but they're often in the footnotes. Many of the statements that are argued to be genocidal by South Africa have been made on X. A number of the evidence collected are made on these platforms. And certainly from a policy perspective, outside of the scope of this case, it's important to note that these online platforms, regardless, have other arguably binding responsibilities under international law that could be relevant to this conversation. Again, I expect them to come up more as footnotes and as part of a larger conversation rather than as a central part of the case. But I do think there are a few areas, if you will, that have come up over the last few months that have been some of them cited directly in the case, and some of them more kind of coloring the larger political context, if you will. The first, of course, is the removal of videos deemed to be violent under the justification of either fighting terror or extremism. Unfortunately, we know that these platforms have a long history of removing vital human rights evidence, which could be critical for accountability and justice mechanisms down the line. We saw this with YouTube in Syria. We saw this with TikTok in Ukraine. And we're seeing it in this context as well. And so those working on evidence collection are paying attention to this, are engaging with platforms, are putting them on notice that this is vital evidence that could be relevant either in this case or in future cases as well. Second, in many cases, these platforms are where comments inciting to genocide and flourish and spread. Often they're made by Israeli officials, and these comments have been screenshot and added to case files. We saw this particularly in this case. But beyond that, there are serious concerns to consider when it comes to how these comments or the space more generally allows for everyday users on these platforms to promote incitement to hatred, violence, dehumanization of Palestinians, the promotion of genocide, and how they're moderated or not. And there's a whole host of legal obligations that come into play here. Again, they're not the focus of this conversation, but I think they're very, very relevant when we look at the larger context in which this case exists. And I believe we can't separate the things. Third, there's been a failure to properly deal with misinformation and falsified videos and evidence. I spoke about this earlier, but I think the fact checking, if you will, the removal of content, these are areas on which platforms need to further engage and are which they're on notice for. And fourth, maybe the shutdown of pages or the removal entirely from platforms. We saw this particularly with pro-Palestinian pages, but not solely so. The removal of Quds News, for example, on Facebook. Some of these removals have been permanent. Some of them have been for temporary periods of time, and relatedly shadow banning. So I think ultimately when we step back, tech platforms should be on notice, both that the posts made on their platforms are being cited to in cases like this ICJ case, but also reminded, if you will, if their obligations well beyond this case under international law. They should be consulting with those most impacted, with lawyers, documentarians, on how to best navigate these situations. Folks like David have set out a lot of different ways in which they can meet their obligations during wartime and otherwise. But I would say also this is a very unique situation in light of the dynamic nature of this conflict, if you will. And so that continued consultation with those most impacted is critically important.
Yeah, thanks a lot. And I think, I mean, the platforms have, some of them have seen themselves at the receiving end of claims as well and litigation, both in Ethiopia, for example, in Kenya over the situation in Ethiopia, or when it came to the failures around the genocidal situation in Myanmar. Yes, anyone want to comment briefly on this point? Well, you will go ahead.
Yeah, briefly, I basically agree with just what had been said, just flagging that there were two oversight board decisions that already pertain to this conflict, both involving removal of contents, one regarding the Shifa hospital, one regarding Israeli hostages. And in both cases, the overboard decided that for the reinstatement of contents with any required advisory language on graphic content and the like. So the matter is also it's already been litigated, so to speak, within the context of at least the Meta oversight board. And I also want to flag that the business and human rights framework does talk about specific responsibility for states, actually, with regard to companies in times of conflicts. So there is this at least mindset that within the business and human rights framework, that most of the major companies have accepted that they have particular responsibilities to uphold human rights in times of conflict.
And Chantal, the one thing I would add to that is, the European Union or the European Commission has also expressed an interest in this issue. It wrote letters to, or at least Thierry Breton, who has kind of oversight over the enforcement of the Digital Services Act, which has only recently entered into force, has basically sent letters and initiated efforts to ensure that Twitter, Meta, and at least Twitter and Meta, maybe TikTok, are in fact meeting, whatever he perceives to be their obligations to prevent, the kind of sort of online and offline harms that are covered by the DSA. So we'll start to see, I think, more, if not law, at least some kind of legal compliance questions coming up in this context, and they'll come up in this context not only in the region but in other places where there's a sense that sort of the spillover online has an impact on these jurisdictions.
Yeah, thanks. And I think Breton's letter are also a good example of how complicated this space is also to navigate, because we did call out that there was a risk that his letters would basically call on the platforms also to maybe over-remove content in times of conflict, where again documentation is so essential. And I think we're all in agreement that platforms can do more, and there's still quite a lot of room for improvement as to their practices. Before we turn also to some more questions from the audience, one thing that we have been thinking about, it looks like the ICJ is going to be used more and more also as a forum to seek accountability for human rights atrocities. As we discussed, it needs to be usually brought under the Genocide Convention, because it's the only way in most cases to really get to the ICJ. At the same time, compared, for example, to the European Court of Human Rights, there is much less opportunity for third-party interventions, for human rights organizations to submit something to the ICJ in a way that it will be part of the case file. So, Jiries, maybe to put the question to you to start with, do you think the rules should change? Is there a risk? Is there value in that? And what would actually be required? Is it likely that this is going to happen?
Yeah, thank you. Personally, do I think they should change? I think there would be value in that. As you said, there are other international courts and tribunals that benefit from interventions from NGOs. You cited the European Court, there's the ICC, for example, and I think there are mechanisms whereby the court retains control over the process. So it's not a free-for-all where anyone can just submit whatever they want and it has to be taken into account. So there are potential protections that the court can impose to make sure that the implications, the workload, the sort of usefulness of the submissions is maintained. So on a personal level, I think that would be a beneficial thing, but on a practical level, the world we're actually in, it's not going to happen, frankly. I mean, the ICJ is bound by its statute, and the statute is very clear, or at least the statute is very clear in the restrictive way that it has been interpreted by the court to date, and I don't see that changing. So there are two types of cases. As we know, there are contentious cases, such as South Africa, Israel, a state on each side, and there are the advisory proceedings. So for contentious cases, proceedings, Articles 62 and 3 allow other states to intervene in certain circumstances, which I don't need to get into for the purposes of this discussion. And for advisory proceedings, Article 66 is the governing provision, and that empowers the court to seek written statements from states or international organizations that are likely able to, quote, furnish information on the question. But the court has made it clear that it interprets international organizations in that context to mean governmental international organizations. And so that is the framework. What has happened in the last I think it was in 2004, there was a practice direction by the ICJ, Practice Direction 12, which provides that where an NGO submits a written statement and or document in advisory proceedings, so not in contentious cases like South Africa, Israel, on its own initiative, such statement and or document shall be treated as publications readily available and may be referred to by states presenting written and oral statements in the case. So, I mean, it's a very small little chink in the window that the ICJ has allowed NGOs to sort of provide some thoughts, and, you know, we'll take them into account maybe if someone looks at them and refers to them. I don't see that changing. The way it would change, just to answer the final part of your question, is through a change to the statute of the ICJ, which would require 2/3 majority at the General Assembly, and then ratification by 2/3 of states, and that's Article 69. So not impossible, but unlikely, not on the agenda as far as I know, and would require probably quite a big NGO movement to persuade states to do that. But I see hands up, so I'm willing to be corrected.
Well, thanks first of all for managing our expectations on this point, but welcoming maybe more hopeful remarks from others, or maybe confirmatory. You will go first.
Yeah, no, don't worry, Joris. I'm in full agreement with you. What I actually wanted to say is that we are seeing a change with regard to state interventions. I mean, this is something that was very rare in the past and happened in very specific cases like border delimitation, where maritime boundaries between two states impinge on the maritime boundaries of a third state, and but now you do have massive interventions by states in cases that have a public interest dimension. So we've seen this in Ukraine, Russia, we've seen this in Gambia, Myanmar, and although we haven't yet, we've seen one application in South Africa, Israel, but other states have already announced their intention to intervene, so to speak, on both sides. So Germany has announced that it plans to intervene on Israel's side, and since has been dragged to the court on a different case. And there have been other cases who have expressed an interest in intervening on the South Africa side. So for the court, this is, again, in the management of expectation mode, this is already a very significant change in the way it does its business. It's creating quite significant procedural headaches for the court. And we are seeing this now with the Nicaragua case, an intervention, which is unique. The intervention is unique, hasn't been tried before in this public interest litigation type of case. So the likelihood that the court would now take a new adventure on board when it is still not managed how it's going to deal with the existing challenges is rather unlikely.
I found this on the web.
Go ahead.
Sure, I'd love to come in on this. A few things. I also, Jiries, agree with you. I'm not gonna disagree with that finding. But what I wanted to say is related to what you all said. I think what's unique about this case is the fact that the ICJ is the center of so much attention. I think that's unusual for the court. It's unusual for, frankly, international lawyers. Many of us joked that our parents were calling us, asking us what is going on with this case out of public interest. That's something that's quite rare. And so I think that that's something both, yes, a headache for the judges that might be more conservative or are used to doing things a certain way. But in my opinion, on the long run, if we think about it as strengthening, tightening international law, allowing international law to have greater protections for greater amounts of people and filling the gaps, I think it's a good thing to be engaging with. Certainly, there's going to be kind of legal, we have to stick within the legal framework, if you will, but I do think it's a very interesting moment to see these states want to intervene, to see the amount of non-lawyers even watch the case, to see how people are pushing arguments that are creative, even if they ultimately aren't taken. I wanted to quickly just note that the Genocide Convention is not the only way to get to the ICJ on human rights issues. We saw recently through the Convention Against Torture, Netherlands and Canada brought Syria to the court on torture allegations. And similarly, provisional measures were ordered that Syria is similarly not adhering to. However, a very interesting part of that case had been the fact that Canada and the Netherlands both conducted listening sessions before they built the case with victims, survivors, and civil society organizations. Now, this obviously is not a legal obligation, but it's a very interesting way to consider building in more of a civil society and victim-centric component into the case. Of course, that process was not without perfections, but I think it would be very interesting to see behind the scenes the work perhaps that South African lawyers are doing to engage with Palestinian organizations, to engage with those doing documentation, and also the work then that organizations are doing to explain even what's happening with the proceedings and make it a little bit more accessible for non-lawyers as well. And so with the caveats that we don't have official channels for civil society intervention, there are many other things that states could be doing and interested parties could be doing as well.
And just
Chantal, at the risk...
Sorry, very quick.
Just very quick.
No, you go ahead.
Yeah.
David first,
so,
and then Jiries.
Yeah, let me just very quickly, because I mean, you probably, Chantal, don't want this to be like an ICJ driven only kind of conversation, but I think this conversation is very interesting, and I see it as sort of a set of positive things that are happening, and just want to make 2 points. One is this kind of, I think of it as real-time justice, which it feels new, but actually the United States in 1979, brought a claim against Iran in the early days of the hostage crisis, when Iran had taken, several dozen American hostages at the US Embassy. The United States actually used the court as a part of its, say, arsenal of international law to make the claim that Iran was in the wrong there. And in a way, we're seeing a legacy of that. And from my perspective, if more states do these kinds of things, obviously you want them to be done in good faith and all of that. But I actually think that it's not a bad problem for the court to have. Over time, it would figure out, new modes of work. It might figure out new standards that it has to apply in provisional measures cases, very low standards or burdens at the moment. Maybe that would change if there are more cases. I don't see that necessarily as a problem. I mean, it's a problem to the extent that states don't comply with the decisions, but it could be potentially, because it's right now, I think we're in sort of an open moment, but it could be a good opportunity for the court to sort of put itself forward as, a player in asserting that international law has a role to play, in our consideration of really big, important political issues.
Jiries.
Yeah, I mean, I fully agree with that. I think it's good and important that the court is at the center of attention now. I mean, there are large screens up in The Hague outside the court for people to watch. That's unheard of, and I agree with David and Mike that that's Good, and I just wanted to make the point that there are also other, I mean, I think there's an unexplored wealth of potential conventions and treaties that could be used. I mean, there is the Convention on the Elimination of All Forms of Racial Discrimination, which has been used as well recently by states to bring cases before the court. So, I mean, I think there is now a ramp of states thinking about these and either bringing cases or intervening in cases, and the court will and should find new ways of working, because I don't see it stopping. And this has really brought, this case in particular has brought the ICJ to the world's attention like no other so far, and I don't see it stopping. And I think they will need to become more alive to the sheer amount of cases that are going to come before them.
Yeah, I agree. As you say, it's underexplored, but I think it's very much being explored as we speak, and it will be more cases will be brought along the same lines, I think. Turning again to questions from our participants, going back to this question of incitement to genocide in a very sort of practical manner, what does Israel have to do right now? Do they have to prosecute incitement to genocide, or else they will be responsible for it? Do they have to sort of preemptively fire someone to comply with the obligation to prevent direct and public incitement? What is it that they have to do now? And linked to this question is also obviously that they have had to submit their first report after 1 month, but we do not know because it's confidential what that report looks like, which is also a little bit unfortunate given the spotlight on this case. But I don't know if anyone wants to comment on this question. Yuval, obviously.
Well, I'm happy to talk about the first part. I mean, on the second part, I can say a couple of things, but maybe I share your hope that these things will be more transparent. Although I would say that this is, unfortunately, this has been the routine in the other cases where reports have been submitted. They have not been disclosed. So that's in the Myanmar case and also in the Armenia-Azerbaijan case, where reporting has been done and it's not been transparent. But I have a feeling that maybe in this case, because of the significant attention, I mean, it will find its way to the public realm. On the issue of what Israel has to do, so here maybe I wanted to pick on something that David said. I'm not sure, which I'm not sure. I still am not sure that I fully agree on that, is whether it is an interstate case, but the specific obligation to prevent and suppress incitement to genocide is premised on the actual existence of a prima facie violation. So I think what Israel would have to do is to review the statements that have been identified as problematic, and like May said, there are many statements that fall within that category, and then evaluate whether they violate the obligations of Israel under the Genocide Convention, namely whether they could be read as non-ambiguous direct and public incitement to genocide. I would say that there are other, the Israeli Attorney General has already stated that she is going to investigate inciting statements. She did not actually indicate that she will investigate them only on the basis of the Genocide Convention. The Israel criminal law mirrors more or less Article 20 of the ICCPR. So there would be the possibility of bringing indictments not only on the basis of incitement to genocide, but also on the basis of other incitement-related offenses. So the expectation would be that if prima facie evidence exists, that she will submit indictments or move in that direction. There is a specific problem, legal problem, given the fact that some of the speakers do have immunity because they are serving members of parliament or of government or the head of or the president. And there, I think this is going to be something which, if Israel is serious about tackling this, and I agree that this is a serious issue, and the reason why Judge Barak joined this, I think that he also shares this position, that this is actually a serious problem for Israel. There will have to be, in an ideal situation, there will have to be political repercussions. Namely, the prime minister should fire the minister who has made the statements. In the real world, this is not going to happen. Because the prime minister himself has also made some statements that are, I don't know if they're full incitement, but they're certainly inappropriate. And secondly, the way politics run in at least in Israel is such that there is at this point in time very limited accountability on all fronts. So it's not very likely to happen, unfortunately.
Chantal,
yes.
one thing I would just on this question of what the court would actually be looking at. I mean, I don't know, but you could imagine the court essentially addressing this much as the International Criminal Court would address complementarity questions. So I could imagine the court sort of asking, what has Israel, putting aside, because I'm not sure that it will do a kind of de novo review of whether particular cases were in fact incitement to genocide, but it might look to whether Israel in good faith carried out this obligation. Even if the outcome is that it didn't find a case of incitement to genocide. It's just this case presents a very interesting, like in a whole bunch of different areas, a question of to what extent will the court import approaches from other institutions and other frameworks of international law to reach its conclusions. I don't think we know yet, but I think it's possible that it would stick to its state responsibility, obligation here, and do that kind of almost like a complementarity review. I don't know that that's true, that will happen, but I think it's possible.
Jiries, did I see your hand? Yes.
Yeah, just on that point, I think the fact that this case will take years is sort of playing against Israel in a way, because it provides a sort of ongoing supervisory thing where, Israel's not going to be able to say, if it were minded to, oh, it's the heat of the battle, we can't do anything at the moment. When it comes to the merit stage, there'll have been a long time, presumably from when this current phase ends, and there will have been a chance at least to go through the steps of legal processes and deal with problematic statements and other problematic actions. And to the extent Israel hasn't done that, then that's going to be very noticeable. That was my main point that I wanted to make.
Yeah, it will be interesting to see whether it's dealt with as some sort of almost like due diligence obligation, and again, overall, have they shown that they've done enough and they've been serious without obviously questioning probably the individual decisions of domestic criminal courts, I would assume, but really remains to be seen. One question was raised as well, and maybe without getting into the details between these different ICJ proceedings, but it's true that there has also been a recent decision in Ukraine versus Russia. Then we have Gambia versus Myanmar, of course, as well. So there are these different parallel and pending cases before the ICJ. So perhaps, I don't know if you have any thoughts on how the court decided those differently so far, or will the court consider them? Do you think when deciding on the Myanmar case, will they consider what does this mean if we decide this now for then Israel? Will they have these like different scenarios in parallel in mind as well? Anyone? Yes, Yuval, go ahead.
I'm willing to defer, but since no one raised their hand, I thought, yeah, I'm pretty sure that the court would think long and hard about how any standard that it would decide to develop. And I agree with the point that was made before, that there has been some criticism of its approach in the Serbia cases, which put the bar quite high. And even a country like Germany, who intervened in Myanmar, called on the court to lower, to some extent, not to a huge extent, but to some extent, the bar, and I think the court would have an opportunity, probably first in the Myanmar case, to do that. But I'm also sure that when doing this, it will have. I mean, it's really, maybe it will of course not say anything about this in the judgment, but for judges who are, you know, human beings, and they are hearing these different cases coming up in the same couple of years, it would be impossible for them not to think of how application of a standard in one case would not apply. I mean, how it would apply in the other cases. It's simply inconceivable. So this might be beneficial, or I mean, we still don't know whether this is going to, for those who are pushing for lowering of the threshold. The fact that these cases are becoming more frequent could convince the court to re-examine its approach, but could also lead some of maybe the more conservative judges who see these decisions as putting the court in the crosshairs, so to speak, of political action, as something which maybe is not so desirable. So maybe they would not be so keen on inviting more litigation of that sort. So I think we will have to see, and this is going to be a very important choice that the court would make for all of these cases.
Yeah, I think so. I think also it will be interesting with the interventions who have been compared ahead of the Israel hearings, for example, when they looked at what did UK say when they intervened in the Myanmar case, and how does it fare against their positions in, for example, South Africa against Israel. David.
I only wanted to say that the ICJ has notoriously bad fact-finding capability, and to the extent that the court is asked to draw conclusions based on facts. I mean, we already saw this even in the provisional measures phase, that it was 3 hours of South Africa and then 3 hours of Israel, but there's no testing of the evidence, and even in or testing of the allegations, and even in merits phases of cases, that the court has just made very, very minimal use of fact finding. And so, I mean, I say this mainly to kind of throw some cold water on the court's willingness to get engaged in fact heavy kinds of cases. So I do think that the extent to which more cases are brought, more complicated ones, more political ones are brought, the court is just going to be forced to change its evidentiary burdens, its what it signals to states, to the General Assembly and other institutions that can bring advisory opinion requests. I think we could see it start signaling we don't want these cases, and that's, I mean, I'm unclear how it would do that, but I think that's a possibility if more of these cases come up. So there's kind of a double-edged sword around these things.
Just on the intervention point, the discussion about what Germany said and other states. So Germany filed a submission, a joint declaration alongside Canada, Denmark, France, the Netherlands, and the UK in Gambia and Myanmar. Now that was under Article 63, and the point of Article 63 is that then if you intervene in proceedings, that construction given by the judgment because you're intervening to give your view on the construction of a part of the convention, not on the facts of the case. So that construction is then equally binding upon you. So I don't think those states are going to be able to row back on what they said in that case. And arguably, they're not going to be given another chance to give a different construction in a different case of the same provision of the convention. Why would they be given that chance? So that will be an interesting thing to watch. They're not, just to be clear, so I think the point I'm making is they're not intervening in the case on the facts of the specific case. They're intervening under Article 63 on the way that the treaty, in this case the convention, the Genocide Convention, should be interpreted.
I want to maybe open, as we're going to be out of time in a few minutes, but I want to maybe close with a question that has also received quite a bit of attention, also for those people who work closely on platforms responsibility. And it's Israel's paid adverts, which some of them have been viewed as legitimizing or justifying the way that they conduct the military operations in Gaza. And can they be used as evidence as well? How do they play into the question that you said earlier about maybe disinformation about how they've been conducting the military operations? Are they evidence of inciting behavior as well? What do you think about this? And also, what should platforms perhaps do if given a very simple question at the end?
I don't know anything about the advertisements, so I'm not going to. I can't really say anything about those per se. In sort of closing, at least for my last remark, go back to what the order actually says on this. So it says that Israel must take all measures within its power to prevent and punish the direct and public incitement to commit genocide. And I think that has, again, unclear what it means. They didn't say the same kind of thing in the Myanmar Gambia case. So what it means is unclear, but it could be interpreted to create a kind of burden on Israel to address incitement on the platforms. What does that mean? It's not directly, this isn't an order that directly impacts what the platforms should and should not do, but it suggests at least one, that Israel should be very mindful of the kind of rhetoric and incitement that may be taking place on the platform and be a part of ensuring that it's addressed by the platforms. And secondly, I think the platforms should read this, even though they're not a direct subject of this, they should read this as integrating this as a part of their human rights due diligence, even if it's not legally required for them to do that. Maybe that applies to the advertisements, but I'm not familiar enough with that to know.
Very quickly on the advertisements, they vary, so it's hard to speak about them in one sort of type of content, if you will. There's an infamous Hulu ad that talks about what Gaza would look like if not for Hamas, and kind of erases Israel's role in what happened. There are other ads that are sort of more explicit and lean more toward incitement, if you will. So they vary. Some of them are on platforms, some of them are on television. We saw ads around the Super Bowl. I think from a legal perspective, I wouldn't be surprised if South Africa built in some of the content of these ads in building this larger picture on establishing intent and how this is part of a larger plan. Again, like we've discussed before, I don't know if the court will accept that argument, but I think it's on South Africa to kind of be creative and establish and see kind of how far it will be able to take this as well, and its relevant context. I think for me, my final point is really, this has been a very interesting and dynamic legal conversation, and it's interesting for all of us as international lawyers. But I think at the end of the day, these are issues that affect everyday people, and international law, in my perspective, was created to protect the greatest number of people. So I think it's critical, as folks who are keen on developing international law and pushing it to protect the greatest number of people, for us to also be creative. Yes, we want to be realistic with what we're working with. These are old institutions that lean conservative, that want to stick to the letter of the law. But at the end of the day, this is an ever-changing world where we now have social media, where we now have all sorts of actors, where we have this great amount of access to information. And I think that really necessitates the way in which we think about how international law can better serve populations. So from my perspective, I'm excited as a nerd to see how South Africa kind of uses the law to make these innovative arguments. Whether or not they're successful, I think there's still immense impact for how we think about lawyers, about the protection of civilians.
Thank you so much, May. I couldn't agree more. Yuval, did you want to add the final thought as well?
Well, final three thought, but very short. So on the ads again, I mean, I would associate myself again with what David said about the Rabat Plan of Action context. So I'm not sure that the Super Bowl is a large following among the IDF. So it will have to whether this actually is incitement has to be also. I mean, the target audience also has to be factored in. So that's I think a very different set of issues from the statements that the case itself cites. So the second thing I want to say on the I mean, we have to be interim measures. I think we have to be somewhat careful about superimposing on interim measures everything that, you know, every international law grievances. I mean, interim measures are very particular and ultimately quite modest devices that are used for a very specific purpose. And I wouldn't, I mean, I would resist reading into them every human rights related or problem that one can think of. And finally, Mai's point, I agree that it's good that international law is being used and that these issues are being fleshed out. I do want to also basically caution against having excessive expectations about what courts can do in these contexts, given the very narrow framework. I mean, in Bosnia, Serbia, we know that the decision of the court has been received with huge disappointment in the Balkans because the jurisdictional basis was so narrow. So the fact that the court rejected most of the complaints, most of the charges, was seen by Serbia as a political victory. And I think one has to also, when thinking about bringing these cases, you should be also mindful of the very real possibility that they could result in big disappointment. So that's just in terms of where we are and what expectations should we invest in these procedures.
Yeah, I agree. There's always, from a litigation perspective, you should always take into account also what could the repercussions be if you get a negative judgment, because it's a lot about evidence, it's a lot about legal standards, as Mai said. It doesn't necessarily reveal the whole truth of what's been happening in a conflict or on the ground, but this is the reality that we have with the
yeah, and just Ukraine suffered 2 major blows last month from the court. Which I think were legally devastating for it. I mean, it effectively lost one case, and it is on the track to lose the other case as well.
Yeah. So we will have to close now because we're already a couple of minutes over. We could be discussing for much longer. There's a lot of questions that are not just freedom of expression related, but really more broadly about the future of the ICJ as an education forum for human rights violations as well. But May, David, Jiries, Yuval, thank you so much. It was very insightful. I certainly learned a lot to think about. So thanks for your time, and thank you also for everyone who participated with your questions. And yeah, we will be discussing certainly these issues over the years to come. So thanks everyone, and have a great rest of the afternoon.
Thank you very much. Thank you.
Thanks, Chantal. Thanks, everybody.
Bye-bye.